Welcome to Rochester Law Center, and thank you for being with us. Today, we're going to be talking about the differences between revocable and irrevocable trusts. Trusts are one of the best and most commonly used tools in estate planning. A trust is a legal entity that can own assets. Like a last will and testament, a trust includes instructions for who you want to handle your affairs and receive your assets when you pass away. Trusts are generally broken down into two categories: revocable and irrevocable trusts. At Rochester Law Center, we get a lot of questions from people regarding the differences between the two. Today we'll discuss those differences to help you understand which may be the best option for your unique situation. One of the major differences between a revocable and irrevocable trust is that a revocable trust can be changed at any time. An irrevocable trust, on the other hand, can't be changed once it's created. For example, if you create a revocable trust and you want to add or remove a beneficiary, you can amend the document at any time instead of having to make an entirely new trust. Additionally, you can revoke the entire trust if you decide that it no longer serves your purposes. You can't do this with an irrevocable trust. Flexibility is one of the many advantages of a revocable trust you should take into consideration when comparing the two. It's also why revocable trusts are one of the most popular estate planning tools. Now you might be asking, if revocable trusts are so popular, why isn't every type of trust revocable? The main reason someone may choose an irrevocable trust over one that's revocable has to do with creditors and estate tax considerations. Because the assets in your revocable trust are still considered to be owned by you, this type of trust doesn't protect the assets in your trust if you're sued. Additionally, the assets in the revocable trust are still considered when doing Medicaid planning and may be subject to state and federal estate taxes at the time of your death. But revocable trusts have a lot of advantages. In this section, we'll talk about their top 5 benefits. Flexibility is one of the major benefits of a revocable living trust. It's also one of the reasons why these types of trusts are so popular. Having an estate plan in place is essential for securing the future of your loved ones. But it's also nice to have the peace of mind that you can easily change your trust if any circumstances change in the future that would cause you to want to change your original planning considerations. Another benefit is that unlike a last will and testament, a revocable trust allows you to avoid probate court. Probate court is the legal process through which the court ensures that when you die, your debts are paid and your assets are distributed according to the law. It's good to avoid probate because it can be very expensive, it takes a long time, and it's a public process. This means that anyone can see the size of your estate, who you owe debts to, who will receive your assets, and when they will receive them. Since there's generally no probate court process when you have a revocable living trust, there's no need to make your assets or your personal wishes public. Since the trust foregoes the need for probate, the contents of the transfer stay private. Additionally, most transfers take place within a matter of weeks instead of potentially years if you were dealing with probate. It's difficult to undermine a revocable living trust, because the person challenging has to prove that the document is invalid or that you were influenced by an outside third party. It's hard to substantiate claims of incompetence with a trust because you actively manage it your entire life. Additionally, only your beneficiaries that are named inside the trust are entitled to notice and the right to see the trust's contents. For this reason, if you disinherit an heir in a trust, it's less likely that they will know to contest the document. It's not uncommon for an individual to become ill and incapacitated before they pass away. One benefit of a revocable living trust is that it can plan ahead for disability and prevents the need for a conservatorship if you become incapacitated. A conservatorship is when a court-appointed representative is given the authority to manage an incapacitated person's financial matters for them. This situation could be less than ideal depending on your family dynamics and circumstances. Avoiding the need for a conservatorship is especially comforting to families in times of difficulty since they don't have to worry about going to court in a time of stress and sorrow to request access to the incapacitated person's finances. Now, let's talk about irrevocable trusts. An irrevocable trust is a type of trust that can't be modified or revoked after it's created. The terms of the trust are essentially permanent. The creator of the irrevocable trust, also known as the grantor, transfers all ownership of their assets over to the irrevocable trust. This legally removes all of the grantor's rights of ownership of the assets and transfers them to the irrevocable trust itself. As a result, the trust can't be modified without the permission of the trust's beneficiaries. Some of the most popular irrevocable trusts are Special Needs Trust, Irrevocable Life Insurance Trust, AB Trust, Asset Protection Trust, and Charitable Remainder Trust. If you'd like to learn more about these types of trusts, I'd encourage you to visit our website at rochesterlawcenter.com. Trusts are one of the best tools to use when estate planning. Revocable living trusts are the most common and popular trusts due to their flexibility and the protections they give to your assets and beneficiaries. Irrevocable trusts, on the other hand, can't be revoked. However, they're useful for certain circumstances where estate taxes and creditors may be a concern. Estate planning can be complex, and it's usually best to consult with an experienced trust attorney when deciding between a revocable and irrevocable trust. If you need help setting up a trust, we can help. Over the past decade, we've helped thousands of clients in all matters of estate planning. Just give us a call today to schedule your complimentary consultation. We offer phone and web consultations in addition to traditional in-office meetings. Let our staff know that you prefer to meet with one of our attorneys in the comfort of your own home via phone or web conference, and we'll get you scheduled based on your preference. Call us today at 248-613-0007. Again, that number is 248-613-0007. Thanks for joining us today, and we hope to hear from you soon.